Everyone, and good afternoon, and thank you for attending today's webinar. I am Diana Murray with ASAP Accounting and Payroll. We are a Colorado-based accounting and payroll processing firm. We have 3 offices in Colorado: Durango, Telluride, and Golden. And ultimately, our goal is really to be a resource for our client and for our community. So thank you so much for having us here as our host, and we're very excited to introduce our speaker today. So with that, I'll introduce Michael Santo of Bechtel, Santo & Severn. And ASAP. That's my favorite picture of you, Michael. Anyhow, we have had the pleasure of working closely with Michael with our mutual clients. And so with that, I'm excited to turn it over to you, Michael, and give us our update for today.
Thank you. Thank you so much for asking me to come speak. I certainly appreciate the opportunity. This has been a really quickly developing administrative update over the last few months, as you'll see as we kind of go through this information. There is, as Diana said, there is a defined Q&A period at the end from, I think it's 4 to 4:15 or something like that, the last 15 minutes. But please don't hesitate to shout out or type in or questions as we go along. That way we can just address the issues as they come up, because there'll be a bunch of things today that that are a little different than we've certainly been working with in Colorado. So as we do that, what we're going to focus on is the Colorado Overtime and Minimum Pay Standards Order Number 36. That is quite the mouthful. Frequently just referred to as COMPS, C-O-M-P-S. And so that's what we're going to talk about today. As just for background purposes, the wage and hour background in Colorado for those Colorado employers are the 3 laws we primarily focus on are the Fair Labor Standards Act, which is the federal law, and it has really been since really 1939, kind of been the main law we've focused on for all wage issues. That has been really what we see most litigations on, most organizations working with. We then have also the Colorado Minimum Wage Order. The current order only covers 4 quote-unquote industries. It is the current order, which is the order that was in effect on January 1 and frankly in effect right now, because the new order does not go into effect with respect to all the provisions until March 16th, 2020. So in another 5-6 weeks, that's when it's going to go into effect. The salary issue that we'll talk about in a little bit, that doesn't go into effect in July 1 under state law, but we'll talk about why that doesn't really particularly matter for most of us because we're covered by federal law. So currently the Colorado Minimum Wage Order only covers 4 quote-unquote industries. The Colorado Wage Act pretty much covers every employer in the state with the exception of public organizations. That generally deals with issues in terms of when do we pay the employees the time, how can they file lawsuits and those kind of things. The main issues for day-to-day employer issues and how they handle compensation concerns are going to come under the Federal Fair Labor Standards Act and the Colorado Minimum Wage Order. What are the relevant dates? Like, when did we all get started on this? Well, actually, it started almost a year ago now, back in March 6th of 2019. Excuse me, the Department of Labor started accepting comments with respect to the order. It's long been discussed that the order was a little confusing, and since I'm being recorded, we'll call it a little confusing, and that perhaps it could use some updating. In my discussions with the members from the Department of Labor, they acknowledged that it was not exactly the most clearly stated law or order that's ever been written, and so it had been a long time in the making for these type of changes. Then they started taking testimony back in August 28, 2019. In fact, if you go back, there was a public comment period that organizations, individuals could submit public comments up through August 28th. on what they wanted to see. The proposed rule was filed November 15th, but the official publication was not into November 25th, 2019. An interesting date, of course, because for a lot of us, November 25th was basically right around Thanksgiving. And frankly, a lot of us were probably not in the office or thinking about the Department of Labor's wage and hour rules coming out, but that's when it came in. And then they took comments up till December 31st, 2019. I don't know if they still are. I haven't looked to see if you can still submit them even. They issued the final rule. It was supposed to be issued January 10th, 2020. That got moved to January 24th, 2020. And then they actually sent it out about 2 days early on January 22nd, 2020. That is what we'll be discussing today, with a couple exceptions where we'll fall back on what was in the proposed rule and now what is in the final rule. As I mentioned before, everything goes into effect Sunday, March 16th, 2020. I have to admit, I'm not a huge fan. It would have been nice had they started it on a month for those of us with full calendar month payroll cycles. A little odd to be starting it in the middle of the month, but that's what they decided on. And then the new exempt employee, the salary basis goes into effect on July 1, 2020. What are some definitions? We'll be going over, let's go over basics on just the definitions, and then we'll get into the other issues. An employee, of course, means anyone performing labor or services for the benefit of the employer. They basically borrowed the Fair Labor Standards Act definition, which was one of my favorite definitions of employment law, when they call work an employee who either suffers or is permitted to suffer, which is, that's a great way to look at work. We just all suffer. But that's how they looked at it. As one of the interesting things that they talked about in the order was how it could be really the distinction between an employee and an independent contractor. What they did, wasn't too many buttons there, sorry. What they did, interestingly, was that they did identify as the employee that it's consistent with the Colorado statute on independent contractors, where an employee is someone where there's a great deal of control. An independent contractor you don't have much control over, and that they have their own separate business. One of the interesting additions, which was snuck through but came in last legislative term, is this last section on the slide you see up, where it says, and the degree to which the person performs work that is the primary work of the employer. This, for lack of a better term, is really an issue directed at the Ubers of the world, so to speak, the gig economy, where the Colorado State Department of Labor and the federal government and other states are working with this or looking into this, as well as whether those individuals should be classified as employees or whether or not they should be independent contractors. Because most of those organizations are treating them as independent contractors. But what we're looking at here is they're saying is, look, when the degree of control, when the work that the person performs is the same as what the employer does. So, for example, if we hired an attorney as an independent contractor, they would say, well, that would be a strike against the independent contractor designation because they're performing the work in question. So those organizations who are attending or listening to this, who are having workers do the same things that it's in business to do, that is, it could be a strike against. Where this all, when we talk about the issues of when do we need to pay employees, particularly non-exempt employees, as I mentioned, the definition that they carried over was suffered or permitted to work. What we're looking at, everything for non-exempt employees, and we'll get into that term in a second, but everything for non-exempt employees really comes from the standpoint of you have to pay non-exempt employees for when they work, when it's time work. You don't have to pay, you're paying exempt employees all the time, But for non-exempt employees, you're only paying them for the time worked, not when the time is not worked. Examples of what equals time worked, and this is something that is specifically in the order, which I thought was interesting, which is basically permitting the employee to be on premises, doing any, just waiting around for duties or anything along those lines, over 1 minute. That's what's specifically identified in the order, or at a prescribed workplace for over 1 minute, and then we continue on. So putting or removing required work clothes or gear, receiving or sharing work-related information, remaining at the place of employment. So the federal standard was much more, I wouldn't say much more, but slightly, I guess, more beneficial to the organizations because it didn't have necessarily a time clock standard. It looked at more of, when has the employee done something substantive for work? And there's been a lot of cases on that. But the state order came back and said, no, we're going to set this 1 minute rule. So anytime an employee is doing something that takes a minute or more, they have to be compensated. That is going to cause, I think, some interesting issues with respect to emails off the clock, non-exempt employees responding to texts off the clock, and something certainly you'll want to be working with your supervisors to make sure that they understand when an employee is answering questions, responding to things that may take more than a minute, as we go back to that 1 minute standard, this may be something that that an employee can claim, I was working. It was time work, and that's 6 minutes or 4 minutes that I was responding to my supervisor's text about see you in the office for the meeting tomorrow may, in essence, be time worked. So it's a little, it's something we need to keep track of and make sure supervisors are aware of that. Just to go back, this is the information on the employee continued. It does not differ greatly from the Colorado statute. It identified in the order that independent contractors are when there's no control, there's a separate business, they've registered with the state, they're advertising, they're doing all those kind of things. That's what an independent contractor is. When we look back at what the courts have looked at in Colorado, courts have looked at basically saying everything in all the relationships between the employer and the organization is relevant. And the order does not change that at all. It just simply, I think my argument would be it adds something that's relevant, which is does the worker perform the same services as the employer? Okay. As I mentioned, the order currently applies to 4 industries, which are retail and service, food and beverage, commercial support, and health and medical. If you weren't in one of those 4, you weren't covered under the previous order. And there are a number of groups that did not fit into those that there's a question now of, are they now covered by the order? And when I say the current order specifically excludes, I'm talking about the current minimum wage order, not COMPS. I'm talking about minimum wage order number 35, which is going to be effect until COMPS comes in. So the current order specifically excludes the state agencies, the insurance industry, manufacturing industry, community center boards, and construction industry. Those are specifically were exempted in the current version of the minimum wage order. That got pared down in the new version of COMPS, or the final version of COMPS, which is basically they said, well, we're going to apply this order to every single organization with the exception of the following. And they have a number of them, but specifically, as you'll see, states or counties, cities, municipal corporation, quasi-municipal corporations, school districts, irrigation, drainage, conservation companies, or districts. So basically, those are the specific, in general, excluded groups. Everybody else, and there are some exceptions, but for the most part, everybody else is covered. So that breakdown of the 4 that we addressed here is no longer relevant. That is going away once this order goes into effect. So one of the main concepts with respect to all of this law and really all wage law is we have to meet 2 tests under both the federal and state law. That has not changed. The 2 tests under federal and state law would be a salary basis test and a duty basis test. As I say here, meaning one of the tests is insufficient. So you can have the highest paid person in your organization who paid $500,000 or $1 million or some amount of money, but if they don't meet one of the duty basis tests, generally they cannot be exempt. They are considered non-exempt, are now covered. Non-exempt just basically means they're covered. Exempt means they're not covered. Similarly, you can have somebody who is your CEO, your chief financial officer, your president. They can meet that duty basis test, but if they're paid on the by the hour, or if they don't meet the salary threshold, they cannot be exempt. So the first question then became, well, what is the salary requirement? And this is by far, I think, I'd say, probably garnering most of the publicity, although I think that's, I've always found that surprising because there's a number of issues with respect to this. But when you're looking at the salary basis, we're looking at these amounts. So it's going to start July 1, 2020 at $35,568. If you have an employee who's not paid that amount, they cannot be exempt because they don't meet that salary basis test. So no matter what they do, they can't be exempt. And then you see it's going to go up at 5,000-ish for the next until January 1, 2024, when it's going to be $55,000 per year. So by January 1, 2024, if you have an employee paid under $55,000, they cannot be exempt. Thereafter, it will go up by the CPI index, and so it will continually increase, much like the way the minimum wage is going to next year as well. It was interesting because they added, this was not in the proposed rules, they added that nonprofits who have a gross revenue of under 50 million and for-profit employers with an annual gross revenue of under $1 million are not required to comply with the salary basis requirement. And so we do not have to, the salary only applies as of January 1, 2021. Of course, the interesting thing with that pronouncement is the federal law came into effect January 1, 2020, which has already raised it to $35,568. So while it may not be under COMPS, the state order, it is already under federal law. So while at least I don't see that as a big reprieve since we're already looking at it, we're already complying with it. In your materials, you'll see the state, the kind of the levels of compensation and how they're going to. That's actually a little off. This is a little older. I just noticed I got an older one. You can see that how it goes. The federal at the bottom is the red. The blue is the proposed, and that is not the final. Sorry, I didn't make that change. I didn't notice that till just now. And then the other ones, which of course haven't come into effect. I went to the hearing, the public hearing on this, and just to give you a sense, most of the testimony came out in terms of that needed to be higher. In fact, I would say a large percentage of the testimony came out from employees who were saying that the DOL should immediately raise it from its current threshold, which would be the federal threshold of $35,568, should immediately take it up to $60,000 by January 1, 2021. So certainly glad they did go along with that. We then get to the next issue, which is that's the salary. So we've met the salary requirement. Now we're going to talk about, well, what's a duty basis? What are those duty basis tests that we need to have established for to be exempt under the law. So we have administrative. The COMPS calls it, which I kind of like because we all call it that way, executives and supervisors, professional, outside sales, and then we have a bunch of other exemptions. The interesting thing about COMPS is that it said in there, which is this is different than federal law. For years under federal law, they used to say that exemptions had to be narrowly construed and generally in favor of, looked at in favor of the employee, in favor of a non-exempt status. That was I wouldn't say overturned, but changed recently by the United States Supreme Court in 2017 when they said you don't look at them that way. It should be a fair, balanced inquiry into exemptions. COMPS did something completely contrary to that. COMPS came out and said, while the whole order should be liberally construed, the exemption should be narrowly construed. So as you're looking through these, we want to make sure we're looking at that with that understanding that courts in Colorado are going to narrowly look at these exemptions. So there are a ton of exemptions under federal law. As I've talked about before, for those who see me speak on this issue, I always identify, and I think it's in one of these lists, that there is an exemption if any of your organizations make Christmas tree wreaths. It's got to be a wreath. It can't be like garland or anything like that. It's got to be a Christmas tree wreath. If those wreaths are made out of natural evergreens, not the pine cones, although those are nice, but the natural evergreens, and those Christmas tree wreaths which you make out of natural evergreens are made in your home office, that is an exemption under the Fair Labor Standards Act. Probably the pinnacle of my career, despite going to the Supreme Court a couple of times, is when about 7 years ago, I met an organization who actually did that and was using the exemption. Quite a thrill. But these are the exemptions under federal law currently. But because Colorado may or does limit those exemptions, the way we look at the comparison between federal and state laws, we look at it as the most beneficial to the employee. So there is more than a strong argument, or at least a strong argument, that these exemptions are now kind of gone away because in Colorado, we are going to focus on just those stated in COMPS, because that is a benefit to an employee. So as we go, what I'm going to do through some of these, the big ones, is I'm going to compare the current federal law with the final regulations as opposed, so it can kind of compare the two. One of the things that, so when we look at the first federal exemption, which is the administrative exemption, we have an employee who meets the required federally minimum wage, or I'm sorry, salary range, which is $35,568. In the administrative exemption, it states that the employee must have a primary duty of performing office or manual work, non-manual work. The important phrase in the federal law has always been primary duty, and you'll see that in each of the exemptions. What is a primary duty? It is not a time clock standard. The courts are clear on that. And the example I always give is firemen. Firemen are a great example of primary duty, which is what is a fireman's fireperson's primary duty? Well, it's to put out fires. Well, what does a fireperson not spend the majority of their time doing? Well, thankfully for all of us, putting out fires. But it's still their primary duty. So when you look at the administrative, while someone may have additional duties, if their primary duty is office or non-manual work directly related to management or business operations, that would meet that test. You don't have to keep a time clock test to make sure they meet that primary exemption. And then they have to have a lot of independent discretion and judgment. Significant expenditures. I was involved in an audit with the DOL where managers of a certain organization were given $1 million of buying authority for the organization and could basically spend whatever they wanted on that $1 million, although their performance may be judged on it. They didn't have to check as long as they didn't go over $1 million. And the Department of Labor said that wasn't enough authority initially. Now, we ended up convincing them they were wrong, but at least that gives a sense. They wanted the DOL, federal DOL, want to see some kind of policy change, authority of that employee, or substantial financial responsibilities. If you look at the COMPS, though, it has a little different standard, and it has to meet the salary basis test, which all these requirements do, and then it states directly serves the executive and regularly performs duties important to the decision-making process of the executive. And this at talks I've done, and I've spoken about half a dozen times since the proposed order came out, this by far is the part of the order that garners the most debate. Exactly what it means when they say directly serves the executive. It doesn't say an executive, it says the executive. And I have on the second page here even what exactly it means to be the. Is it many? Is it just the CEO? Could you, if you are directly reporting to the executive over your department, is that enough? And unfortunately, COMPS does not define what executive means, does not define what the executive means. So we're left to try to figure out, is that term directly serves the executive? Does that phrase means the individual must report directly to the CEO or president, which would be a departure from, of course, federal law. And then the employee must exercise independent discretion and control, judgment, all of those kind of things. So it matches the federal test with respect to the independent discretion, but as opposed to talking about primary duty, it does have in there some information about directly serves the executive. So the question that gets raised is in our slide here, if you take the organizational chart example and you narrowly construe the exemptions, and particularly in this one, we're talking about the administrative exemption, does that limit the administrative exemption to those two marketing and production managers? So only those who report to the executive of the CEO. Does it extend down to the foreman of fabrication, the foreman of assembly, sales office, those kind of things? Or is it just simply the executive? Something I think as you're looking through your exemptions, or looking to determine if your employees are exempt, that would be something to certainly focus on. The federal executive exemption is the same test, meets the salary test. They again have to have the primary duty of management of the enterprise, customarily recognized department, supervise at least 2 or more full-time employees or their equivalent, so either 80 hours of work. You have to directly supervise as a primary duty those 2 employees, and then have authority to hire, fire, or their recommendations of hiring and firing are given particular weight. That is the federal exemption. Of course, we're now looking more at the state exempt order because that's, I think, perhaps a little more employee friendly, which is the person still has to supervise the work of at least 2 or more full-time, has the authority to hire, fire, effectively recommend such action, and the employee must spend a minimum of 50% in the work week in duties directly related to supervision. So it doesn't use the phrase primary duty in this order. It uses an exact time clock standard, 50%. So that would mean that an individual has to spend, just taking the math, 20 to 25 hours a week in duties directly related to supervision, or they could not meet that exemption. It's no longer a primary duty. They must be supervising during those 20 to 25 hours a week. The interesting thing about this, and this is one of the points I raised when I spoke at the hearing, was that the term supervision is not actually defined in COMPS. There is nowhere that really walks through what it means to supervise or be involved in supervision. So if we look at the Fair Labor Standards Act, the Fair Labor Standards Act does not define that either. Instead, the Fair Labor Standards Act uses the term management. So what I asked the Department of Labor to do is switch that to management, so at least there was a term that we knew how to define. They did not do that. So if we at least look at management of what that means under the Fair Labor Standards Act, interviewing, rate of pay, just directing the work, maintaining production and sales records, handling employee complaints and grievances, planning the work, determining the type of materials, controlling the flow and distribution of materials, providing for the safety and security of employees, planning and controlling the budget, monitoring or implementing legal compliance. At least under the Fair Labor Standards Act, that's how they would define management. I think there's an argument that management and supervision are basically the same, so I could see a court using those terms synonymously. So if you're thinking, okay, I got this employee, they are going to be an executive exemption because their primary duty is supervision, make sure you have a sense, is this employee spending at least 20 hours a week, if they're working overtime, involved in these type of activities? If they are, they can be exempt. If they aren't, it would be an argument. So make sure, keeping in mind that the exemptions are narrowly construed again. So that's the executive exemption. The professional exemption really hasn't changed, and it basically mirrors federal law, which is that you need an individual who has advanced knowledge in a field of science or learning, and that advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual studies. This professional exemption initially came in doctors, lawyers. It's been expanded out to registered nurses, individuals with CPA, if they're CPAs, not bookkeepers, but those specifically with CPAs. One of the things that's come up a lot in the talks I've been doing is the issue of how required is that degree. And the example I give, which I see in a lot of cases, is if you have an employee, let's say you have 5 people in, we'll call them the engineer field, and you have 4 engineers all within master's level into engineering in your organization, and you have 1 employee who doesn't have that degree, but they have been doing the job for 30, 35 years. They know more about engineering than any new college graduate could possibly know, and they've forgotten more than any new college graduate could know, maybe, or master's graduate could know. That exemption professional may not be able to be applied to that position because you have someone who's performing it without a degree. So for example, you can go most of the way through law school, and if you miss a class or don't graduate, it doesn't matter how brilliant of legal mind you are under Colorado law, you still can't be an attorney. You have to get through law school, and then you have to pass the bar. If we don't do one of those things, you can't be an attorney. You may work in a law office, but it wouldn't allow you to be under that professional exemption. The same thing is true here. If you have people in your position and they just happen to have a degree, but it's not required that they have a degree, that will be a concern, because it has to have a professional and prolonged course of study. So one of the questions I have, which that has come up in looking at the exemptions, is, let's say you have Jane, who's been your employee for a long time. She started as a registered nurse. So of course we classified her as exempt because registered nurses are exempt under the law. And then we moved Jane to manager of the department. She oversees a lot of critical work, but she, it's not required as a supervisor to be an RN. You could be a supervisor in this example without being an RN. Is that individual professionally exempt? Perhaps not, because that degree isn't required anymore. Are they administratively exempt? Well, that would depend. How that definition of the executive goes. If Jane is but if Jane is reporting to the chief of nursing, there would of course be an argument that the chief of nursing officer is not the executive. And if Jane isn't doing supervision or management under the Fair Labor Standards Act for 20 to 25 hours a week, perhaps she no longer meets that exemption. So simply by promoting Jane from RN to supervisor, have we lost the ability to classify her as exempt? The outside sales exemption pretty much remained the same as under federal law, not a huge issue. Any other questions? I don't see any. Do employees include volunteers and interns? Not true volunteers and interns. Remember, I apologize, I've spoken 3 times in the last 3 days on this order, so if I've told this already, when we look at who's performing services, we're looking at, really 5 types of workers: employee, independent contractors, we've talked about those, interns, volunteers, and as I always joke, family. You do not want to have them working, no matter how cheap of labor family may be. It just creates problems. So you're looking at volunteers and interns. Volunteers for nonprofit entities, no promise of payment, no promise of benefit. They're doing it strictly for because they like to give to the organization. Interns, more and more COMPS and all this looks at in terms of those through a school program. And it's for educational credit. So I remember a couple years ago, there was a CMU student who wanted to work at various law firms over the summer and offered to intern simply because they were going off to law school and just wanted to kind of hear the terms, get some, glean some legal analysis as they were about to enter law school. And we talked to that person about the problem is he was graduating. And so he wasn't going to be able to get school credits, and you can't volunteer for for-profit entities. So I was telling him that as much as we'd like to have him come on, he would have to be an employee. Other COMPS exemptions: owners or proprietors, covers full-time employees actively engaged in management who owns at least a bona fide 20% equity in the organization, or for nonprofit employers is the highest ranked and highest paid employee and is paid at least the salary threshold. They are exempt. Interstate transportation workers, taxi cab drivers, they are exempt as well. Then we get into what is referred to in COMPS as the in-resident exemption. Casual babysitters are exempt under the law. Property managers that reside on premises are under student resident workers. Laundry workers, those, and we talked about bona fide volunteers and work-study students. These are all exempt under the law. As you see, for the work-study students, that in exemption covers those who need not be compensated, but they are enrolled students receiving credit and bona fide for nonprofits. Agricultural jobs, they heard a lot of testimony, received a lot of comments from those in the agricultural industry. So the agricultural industry were tweaked a little bit and is a little broader than it was under the proposed. They also have a computer exemption, much like federal law, highly skilled. The big difference here in the computer exemption for those who are using this computer exemption is much like the executive exemption. The computer exemption, section C, as you see, it requires them to spend a minimum of 50% of their work week in a combination of any of the following duties. So again, it's no longer primary duty status as it is under federal law, or this is what COMPS says, is it's going to be 50%. Certain salespeople, mechanics, commission sales, those are all exempt. Ski industry, medical transport, transportation employees, and those nurses in the 8 and 80 rule. And then again, we talk about range workers, seasonal COMPS, or those kind of education. Those are all the exemptions under COMPS. If you're not in one of those, there basically is no exemption. The interesting thing is that a number of things were changed recently in federal law. There is no reference to them in state law, so that may mean they're not there. For example, federal law provides for what we call the highly compensated employee. And this is someone who earns a substantial amount of income, $107,000, and performs at least some of the duty test that person would fall under the highly compensated. That does not look like, at least as my reading, we may see courts change that to say we can use that exemption because there are references to the FLSA in COMPS, but at least initially that for those who use that exemption, that would not looks like it's going to work. Some of you use the fluctuating workweek method of compensation, which is the compensation method where you pay non-exempt employees a salary, and then instead of getting time and a half when they work over 40, they're only, not only, but they only receive half time over 40. Is not that exemption of the fluctuating work week, which is really not much of not too much an exemption as it is a pay system, that is not in COMPS as well. In addition, COMPS talked about, hey, if you fall behind on the salary amount at some point, we're going to allow you to have catch-up payments. We're going to allow you to, at the end of the year, say, whoops, Mike fell under that 35,568. Here's an additional 1,000. Here's an additional 2,000 to catch up. Or maybe here's a bonus that gets you over that salary. State law doesn't talk about that. And so from that standpoint, that is a concern that we may not be able to use those catch-up payments. Any questions? Okay. Regular rate of pay just means what we've always talked about. It is it's an employee's, in essence, stated amount. For example, if we tell Michael, hey, we're hiring you for $20 an hour, well, my regular rate to pay is $20 an hour, and that's how we figure out what my overtime rate is. We multiply my regular rate times time and a half. Regular rate, they did say the, where are we? So the following regular, did I skip the slide I wanted? No. These are pay that is included in the regular rate. So the COMPS order went into detail in terms of if you do any of these must be included into regular rate. So for example, if you pay shift differential, if you give a non-discretionary bonus, if you tell an employee in your handbook, for every year at the organization, we're going to give you a $100 holiday bonus. So if you've been here 5 years, you get $500. That's a non-discretionary bonus in essence. If you tell an employee, when you produce 500 widgets this quarter, we're going to give you $500. Those would be non-discretionary bonuses because you're telling employees what they will earn, how they can earn it, and those needed to be included in the regular rate, so they're going to bump up that employee's overtime rate. Pay not included, any business expenses, bona fide gifts, discretionary bonuses. So if you just say, hey, great job, everybody, here's $100, that would be a discretionary bonus. That wouldn't need to be included in. Someone asked me a couple years back, they had a Halloween costume and it was a $100 first prize, and whether or not that would constitute a non-discretionary bonus. So shockingly, there's not a lot of case law out there on that, on the issue. So, Diane, any questions? I'll keep going. Okay.
Hey, Michael.
Yeah.
There was a few questions on exempt. I think we might be able to answer them quickly. Let's see. I'll just start naming them. If we have an exempt employee works between 40 and 50 hours a week, but does not have any person reporting to him or her, does that disqualify them from being exempt?
If they don't have any, so walking through the exemptions, the big ones the main ones we'd be looking at are administrative, professional, and executive, taking them in reverse order. If no one's reporting to them, they're not involved in hiring and firing, it's going to be difficult to meet the executive exemption. If they don't have a degree, they wouldn't be able to meet the advanced degree, a master's degree or higher, something beyond college, they wouldn't be able to meet the professional. So you'd look to the administrative. Do they meet that test? Are they reporting to the executive? Do they have a lot of independent discretion and judgment? If the answer is no, then they would not be exempt.
Would an HR recruiter be considered an exempt position under the administrative exemption?
You know, whoever, you know, normally I hand out little prizes for the first person who allows me to give my favorite attorney answer. It depends, and that would be this one. It depends on that administrative exemption. Are they reporting under the law in terms of the executive, and is there a lot of independent discretion and judgment? Can they give a recruit $10,000 more or $5,000 more, or do they get to pick the recruit without running it by anyone? The more authority they're given to make that decision by themselves, or at least theirs is given substantial weight, the more likely it would be that they're going to be administratively exempt.
Okay, let's see here. If you give a gift card for over $25 to an employee, is that not included in comp any longer? It used to be that we would need to track that.
Yeah, I mean, from a tax perspective, I'll let Diana address that issue. But from a regular rate, if you're wondering, do we include that gift card in? If the gift card is a promise based upon, hey, if you do this, I'll give you a gift card, that would be included in the regular rate. We can't get around a higher overtime rate simply by giving the employee extra income as a gift card. And I'll let Diana address the tax element of it.
You pretty much answered that indirectly as it relates to payroll as well. We want to track that as income. And let's see, does the job description determine the exemption if an employer does not require a degree or rather the equivalent experience?
The job description, that's a great question. The job description is the first place we're going to start, but the problem becomes, does the job description evidence what the job does? So for example, I've had cases where someone said, well, this job description is meaningless because it identifies in here that you have to know how to use the Wang computer. Well, we haven't used the Wang computer since 1988. So how relevant can this be? Those job descriptions are the first place, in particular for the Equal Pay Act, which is another talk, but from the job descriptions are the first place we always look for the exemptions, but it's certainly not the last. And if the employee can say, substantively, I don't do what's in here, and you don't identify that a degree is required, so how can it really be required? Because you don't even identify your job description. You didn't identify it in your posting. Someone has done it in the past without it. That would go a long way to proving it's not a requirement.
Okay, and then a couple clarifications on nonprofits. Could you clarify the statement about nonprofits with gross revenue under 50 million? Are those organizations not required to increase annual salaries to the new minimum?
You are not, make sure you hear my whole statement on this, which is you are not required to increase the salaries to the new minimums for on July 1, 2020. When that goes up under state law, you don't have to increase. It means you have to increase January 1, 2021 under state law. But remember, the federal law is in effect to this right now to the same amount that state law is talking about going to. So for nonprofits, you're complying with the federal law already. So it doesn't have that 50 million exemption.
Yeah,
I'm going to explain why that came in.
And this one is another revenue question. If a company has under 1 million in revenues, the salary level sticks at 35,000 for 2020 going forward?
No, it doesn't. State law does not have the salary threshold come into effect for your organization if you're under that. But again, you're covered under federal law, so you're complying with that anyways already. And you do have to then go up after. The only really organizations that I can figure are benefited from that rule about the 50 million and the 1 million are organizations that are not covered under federal law, because if you're covered under federal law, you've already jumped up. Not a lot of organizations are covered under the federal law. There's just not a bunch.
Okay, I think that's good for now.
Okay, so thanks. So we get travel time rule under federal law had a lot of different things. Is it all in a day's work? Is it a special assignment? Is it overnight travel? A whole bunch of things. State law actually did make it a little simpler, basically saying, look, travel time is any time you're traveling for the organization. If you're doing something for the benefit of the employer, I don't care if it's Saturday, Sunday, midnight, 2 a.m., days you're off, Christmas Day, whatever, if you're traveling for the benefit of the organization, you are getting paid. Now, you don't have to pay them at their regular rates, say back to that example again of Michael getting $20 an hour, you can pay them at a lower rate as long as it's minimum wage. But travel under state law just became much more beneficial to the employee, I think. It's much more expansive than federal law, but perhaps a little easier to understand, basically saying, look, as long as it's not home to work travel, it's compensated. And once you're outside of home to work travel, then it's all compensated. Doesn't matter if they're sitting as a passenger, driving, required to be there. If they're moving for the organization, they're required. They had a little blurb, that second blurb there, if you're working within the premises, it may not be considered, but for the most part, it's going to be considered travel, work time. They have the exemption that these rules don't apply to doctors, lawyers, teachers, those kind of things. What's the minimum wage? There's, of course, the minimum wage in Colorado right now is $12 an hour. We have a reduced minimum wage for people with disabilities and minors that allows it to be reduced by 15%. They were clear, I mean, it reiterated current law, which is 40 hours in a work week or 12 hours in a work day. That's when overtime kicks in. If you have an employee who works 15 hours in a work day and then works 43 hours in the work week, they basically, you don't have to pay them 3 for the over 12 and 3 for over 40. They would only get 3 for both in total. So we're all, right now, if you're now covered, non-exempt employees have to get compensated time and a half. The good news in doing it, you know, as I said, I've done 2 talks over the last couple of days, which were with a live audience, and they were able to throw things at me. I like the web talks because you can't throw things at me when I talk about meals and rest periods, which will be a thought of some of you, which is that the meal period stays the same, which is that every employee who works over 5 hours must get 30-minute unworked, uncompensated, completely relieved of duties. If they're sitting at their, you say, well, they're sitting at their desk, and you know, if a call comes in, they have to take the call, but we rarely get calls over that, and so that must be a unpaid, unworked meal period. No, because they could get a call. They have to sit there, and so the 30-minute meal period is a requirement. One of the things I know some organizations do, really from at the request of employees, some will say, well, the last 30 minutes of your day is your meal period. If you want to just take off early, you can do that. Instead of working, you know, instead of having to miss work from 12 to 12:30, we're going to let you take it from 4 to 4:30 and just go home at 4. COMPS said, no, you can't do that. That they wanted, to the extent practical, 1 hour after the start, 1 hour before the end of the shift. There's an interesting issue that's going to come up on lunch periods in a second, but we'll talk about that with meal or with rest periods. But meal periods, completely relieved of duties. It does permit you to consume a meal period while performing duties, but in that situation, they have to be fully compensated without any loss of time or compensation. Rest period. This was a lot of contention with respect to the proposed. They did make a substantial change, I think, but let's talk about what the basics are, which is that the basics are that you have to give a 10-minute rest period every 4 hours, or any fraction thereof. So 2 or fewer hours, 0, 2 to 6, you see the chart there. Those have to be given. What happened, let me back up, let me just take this as this. A couple of years ago, there was a decision in federal court where an employee made the claim of, look, the law in Colorado says that I have to get a rest break insofar as practicable. So I have to get this 10-minute rest period every 4 hours insofar as practical. Now, the problem is my organization, and it's not practical, or even to the extent it is, I've never gotten the rest period. I've never taken that 10 minutes off. And so if I'm an 8-hour employee and I'm not taking, or if I'm taking my breaks as an 8-hour employee, I should technically only be working 7 hours and 40 minutes. But if I'm an 8-hour employee and I'm not getting my rest break, well, then I'm really working 8 hours. So in essence, I'm working 20 more minutes over that shift than I'm supposed to. I'm supposed to really only be working 740, and instead I'm working 8. And the federal court in that situation, the employer, of course, said, well, the law says insofar as practicable, and it wasn't practical. So we're allowed to not compensate the employee for that time. And further, to require us to compensate the employer for that time would mean that you're, in essence, making us pay for time not worked. Or, if they work 8 hours, now you're making us, because they didn't get rest breaks for that 8-hour shift. So instead of just paying 8 hours, you're making us pay 8 hours and 20 minutes, which is inconsistent with the Fair Labor Standards Act, which is only supposed to pay an employee for time worked. So we don't have to pay them 8 hours and 20 because they only worked 8 hours. And the federal court said, no, we don't like that. We like the employee's argument much better. And so employers, if an employee does not get those rest breaks, you need to add, if they're a 2 to 6 hour or 6 to 10 hour shift, you need to add 20 minutes to their pay. Let me go back to this one. I got those out of order. Where's my thing? So what the initial order, where is it? Oh, it's way down at the bottom there, sorry. The proposed version of the order stated, as it kind of goes off the screen there, I apologize for that. As it goes off the screen, the proposed version stated with respect to rest periods, when an employee does not have a required 10-minute rest period, his or her shift is effectively extended. And so that was the key language, does not have a required 10-minute rest period. Of course, the argument came up, well, how are we going to show that the employee had a 10-minute rest period when they sue us for unpaid, worked rest periods 3 weeks after they terminated? How are we going to prove that they didn't do that? How that they got the time off? And that was a concern, certainly, and we were talking about with organizations maybe coming up with time clock issues. You're going to have employees punch out. You're going to have employees sign off, so on and so forth. COMPS, when the final order came out, changed it to the language which is in bold there, which is when an employee is not authorized and permitted. That's not what, when an employee is not authorized, I'm sorry, I meant to take out the does not have. So it should say when an employee is not authorized and permitted a required 10-minute rest period. So it changed it from does not have to authorized and permitted. What does that change mean? Well, I think it's a fairly substantial change under to the final rules, which allows employers to really tell employees in handbooks, in sign-off sheets, at employee handbook or signing meetings, whatever, you are authorized to take a break. We are expecting you to take a break. You're permitted to take a break. If someone doesn't allow you to take a break, you got to let us know. You've got to tell the organization. And so the language changed from does not have to authorized and permitted. So I think this does not, I think the way the law reads now is that it does permit us to do more with handbooks and policies as opposed to having employees punch out. But that being said, individuals must get their rest breaks. They must be authorized. It cannot be one of those wink, wink, nod, nod things. Employees have to be authorized and permitted to do that. They put in the statute, or I'm sorry, not the statute. They put in the order, if you don't want to do a 10-minute, you can do a 2 5-minute rest period, as long as you have it signed by both parties. That instead of a 10-minute, it'll be a 2 5-minute. That seems a lot of work to me, but who knows? And they also said, hey, if you are governed by the collective bargaining agreement, or if you're an organization is Medicaid funded, meets those requirements, that you need not have a 10-minute break every 4 hours, but it did say that the rest periods must average out to be 10 minutes every 4 hours and at least 5 minutes in every 4 hours worked. So if you are an organization that perhaps has employee who is monitoring certain individuals, but you can't, they have to be monitored, that employee still, to meet this requirement, has to be given a break, has to be given at least 5 minutes. Their average breaks are every 4 hours. Their average breaks over the week must extend out to be 10 minutes. And so that is a requirement under the law. If we don't do that, that's where employees can make a claim for an additional X number of compensation each time. So really what this changes it to is when you look at the is not authorized and permitted, we have to make sure the employees are getting rest breaks. This was a source of a lot of testimony on it, and it's something the Department of Labor is really focused on with rest breaks moving forward. That in essence goes along with the federal case holding from a couple of years ago. Questions on that?
Yeah, we've got lots of questions on this one. This is when everyone's throwing things at you. Okay. Can an employee put breaks and lunches together for a longer lunch?
The way COMPS reads, that would not be permissible. They want to see that in more of the in the middle, not stacked. There's in fact something specifically kind of discourages stacking in COMPS.
Okay, we have 12-hour shifts, so 3 10-minute paid breaks and 1 30-minute unpaid lunch. Is that correct?
That's correct.
Okay.
And then, yeah, 3 10-minute rest breaks every one 10-minute rest break every 4 hours.
Yes. If we have an employee that has been on lunch for 15 minutes and is interrupted to assist the customer for 10 minutes, then returns back to his lunch period, are they entitled to restart their lunch so they are uninterrupted for 30 minutes?
The argument under federal law and state law would be when an individual does not get that 30-minute, and there's an argument that goes down to about somewhere in the 21, 22-minute, if an individual is interrupted before that time period, the 20, 21 minutes, then that cannot count as lunch. So in essence, they would be starting again that clock for the 30 minutes. The other thing to keep track of in that example is an individual who can be interrupted. It's got to be relieved of all duties. It's not just, well, it worked out that way that they weren't relieved of duties. So I'd be a little concerned with the ability of clients to kind of come in and say, hey, I can interrupt you, because if they can be interrupted, that may not meet the standard for completely relieved of all duties. So that standard is, yeah, you have kick back in. Sorry, go ahead, Diana.
No worries. This one kind of relates to one we already covered, but if an employee works with a medical client providing therapy, but they can't leave, can they have a working break?
No. They have to be relieved of all duty. They have to have the ability to just walk away. And if someone, and which is a little difficult, of course, because if you have someone who can't be out of eyesight, or they have to be line of vision, or they're doing something where you just can't walk away. Like, I'm still trying to figure out how this is working for the restaurant industry, where my server just suddenly disappears for 10 minutes while I'm waiting for my blue and onion, because that would be something where you have to make sure that these individuals are getting that full rest break, or they're getting paid for it.
Yeah,
so if they don't get the rest break, you gotta add on. Yep, you could pay them, and you're paying them 20 minutes. It's basically 20 minutes at the end of the day. It's an 8-hour shift. So if it's an 8-hour shift, they get 8 hours and 20 minutes, even though you may have only gotten 8 hours of work.
Okay, I think that's a good, I think I can answer the rest. Keep on going, Michael.
Okay, keep on going. And they have tipped, and for those of you who aren't tipped, they kept the same thing that they've been working on. The lodging credit, they actually changed the lodging credit, which I got a kick out of, because ever since I've been practicing law in Colorado, 1994, and for many years before that, the greatest amount you could charge for a lodging credit was $25 against minimum wage a week. I didn't know where someone lived in Colorado for $25 a week, but that was the full extent you could offset against minimum wage. This is still offset against minimum wage, but they at least raised that to reasonable standards at this point and talked about meal credits and all those kind of things. Uniforms were made the same. Didn't see much in the change in those. One of the biggest changes by far, well, one of the bigger changes is the posting requirements and the effect if you don't post, which is that the state is producing a poster. I've not seen it yet. In fact, I was just talking with a couple other employment attorneys before this talk. No one has seen where this poster, presumably it will be out before March 16th, and all organizations are required to post this poster. So make sure, and we'll send out the link when it's released. Make sure you're posting that poster on your bulletin board, wherever else those posters go, because the impact of them is if you don't post the poster, you lose the ability to get any exemptions. You can, doesn't matter who it is, if the poster isn't up, it basically said, yep, your exemptions are no longer. So for that reason, employers want to make sure that by March 16th, they are posting those posters, because otherwise there's a claim we're losing exemptions. In addition to that, if you have an employee handbook, the COMPS poster has to be in there, and employees have to sign off on the COMPS poster in their handbook. So if you're doing something along those lines, you have to change your handbook by March 16th to include this poster. And if you have a sign-off sheet, as most of us do, you have a sign-off sheet. The other thing you want to have signed off in there is something, you know, it says usually, this is not a contract, employment at will, all those other things. Don't perform off-clock work. In addition to, in addition to that, you'll want to have a sign-off sheet, or the sign-off paragraph, a paragraph in your sign-off sheet that specifically states employees or employee acknowledges that they have received a copy of the COMPS order in their handbook and they will be reading it. That sign-off sheet, I think, is another good place to address the rest period issue, you know, because as we talked about, authorized and permitted, it would be a good place in your sign-off sheet to have it right above the employee's signature. Employees are, non-exempt employees are authorized and permitted to take a 10-minute rest period every 4 hours. If you don't get it, please come see us. Again, document that ability in, or that issue in your handbook. I think will be, I expect will be a key going forward with this. In addition to this, I just have in here about the recovery of wages, which really tracks what it has been in the law, which is that employees are able to file a complaint with the Colorado Department of Labor. In fact, they have for wage claims under 7,500, they even have a hearing procedure if they want to go through those. That still remains the same. They can still also file it directly in court. There may be investigations covered. It came in last year that it could be a criminal violation for improperly holding wages, so something we want to make sure we're keeping track of, because they upped the ante on the violations of law. They've kept jurisdiction. So what can we do to prepare? Well, this is your time to go back through for the next 5 weeks, because exemption language does go into effect March 16th. When was the last time you've gone through and double checked, do our exemptions meet these requirements? This is your chance to look at baseline information. For those of your organizations that are concerned about that increase in salary, trying to decide, well, do we bump this employee's salary up or do we keep it the same? This is that chance to figure out, well, how many hours a week are we talking about? How many hours a week will we be looking at overtime should this be an issue? This is your chance to figure that out. You know, you're looking at the salary basis, you're looking at the duties. And of course, what we say here is be cognizant that some employees may not like changing to non-exempt status when they no longer meet the requirements. And so making sure we're being cognizant of that when we make that out there. Exempt employees, don't forget that you have to meet the salary and hourly. Hourly non-exempts are those, salary non-exempt independent contractors. There may be, I kept this in here, the upcoming public comment, public hearing. I kept this in here because there is a chance, I don't know how good a chance, but the last time, of course, the federal law, the Federal Department of Labor tried to change the salary basis, just the salary basis test. There was a lawsuit filed by, I believe, 20 Chamber of Commerce, State Chamber of Commerce down in Texas, preventing or trying to prevent the law, saying that what the Department of Labor had done was unlawful, the Federal Department of Labor at that time. That lawsuit was filed and an injunction was quickly issued preventing the implementation of the act or the regulations that change the salary. That's still potentially out there here. We could see a similar lawsuit filed against the Colorado Department of Labor. There's a number of issues in terms of how the governments are exempted, how it gives perhaps the Department of Labor has taken more authority than they're entitled to under this. So that may still be coming. I wouldn't rely on that though. We had a big change in the Fair Labor Standards Act, the federal law this year, and there were no lawsuits filed. So the law went into effect. Similarly, you want to start preparing because if you wait till March 15th and oh, well, it turns out no one sued, you got a whole bunch of things to do before March 16th. So from that standpoint, I certainly I would start looking toward the assumption or having the assumption that these are going to go into effect March 16th, that the salary basis will change come July 1. Of course, under Colorado, we're just matching federal, so that's already in place, but they will go into effect January 1, 2021 with the big jump. That's what I believe certainly need to start preparing as organizations. Questions?
Yes, lots of questions. Okay, let's see here. What do you mean by you will lose your exemptions if you don't post jobs?
Yeah, that's an interesting statement, because what they said was, where is it? I have the specific one. I actually had a dream the other day that I was asked a question like this at a talk and didn't have my order handy. It said an employer that does not comply with the above requirements, which would be the posting requirements, does not comply with this paragraph shall be ineligible for any employee-specific credits, deductions, or exemptions in the COMPS order, but may still be required for the employer or industry-wide exemptions. So if you're covered by COMPS, there's an argument that if you don't post, you won't get those employee exemptions, administrative, executive, professionals, that all those go away if there's no posting. So that's what the language in COMPS identifies.
Okay. Where do pastors fall in the duty basis test or the professional exemption?
Well, that's a really good question. I have not been asked that. We will put that in our next newsletter because, of course, that's a distinction in federal law for religious organizations. I got stumped. Religious. I'm writing that one down, and I can't. If I run into you, make sure I give you a free giveaway or something because I got stumped on that one.
Okay, a couple questions related back to the 15% reduced minimum wage. The 15% reduced minimum pay for minors, can you elaborate? Is that a permanent reduction or is that just an introductory wage that has to go up to state minimum wage after a certain amount of time?
Introductory wage, 90, as I recall, 90 days. You just came out 6 days ago, so I haven't memorized everything in there. But as I recall, it was an introductory wage up to 90 days. An interesting question under that is, does a state order from a Department of Labor have the ability to trump Colorado Constitution, but I'm not going to go into that Colorado constitutional argument, but just something to keep in mind out there. But it's for a limited time. It's not forever or never. And you can't fire someone when they hit day 89, rehire them, and start it again.
And why do people with disabilities have 15% less on minimum wage?
Why do they? I don't know the Department of Labor's theory on that. I think it could be those individuals who are employees of, I think that's what they were looking to, maybe individuals who are clients of community center boards. It's not supposed to be all disabled individuals. You can then say, well, Michael, because you have bad vision, we're going to pay you, this percentage less during the day. That was not the intent of the thing. It was supposed to be a very limited credit.
Now we're getting into the nonprofit sector. In terms of nonprofits who can't afford to pay their executive directors the increasing salary, must the executive directors then become hourly?
Yes.
And on the nonprofit,
your question goes to something I asked the State Department of Labor during the hearing, or actually didn't really ask, I just told, was was that I said to them, please remember that you represent the entire state of Colorado, not just the narrow corridor of I-25, and the amounts you're identifying we have different economies of scale in rural areas, Western Slope, and for example, where I'm from, and said, make sure you keep that in mind. They brought it in for the entire state. In fact, one of the things they said was interesting, and I don't know how that's going to work going forward, but basically it said that, hey, employers, if you have an employee who goes into a region or area or county where they have an increased minimum wage, you're going to need to comply with that. So does that mean a minimum wage employee who's driving through Denver area where they have, or Boulder, I forget where the slightly higher minimum wage is, do we then need to pay them for that during an increased amount during their travel through there? So that is also in the order. Yes, sorry, Diana.
No worries. Same thing on the nonprofit budget amount. The copy of the rule this person has shows 25 million, not 50 million. Which is now correct?
I had I had 1250, I thought, but I may have, as I said, this just came out last week. But that is just a short, well, no matter what that is, don't forget, you're already covered by federal law. So that order for the 50 or 25 million, that exemption is not the case in federal law. So if you're covered under federal, you've already moved to 35,568. As I'm trying to flip through it, COMPS. I'll look through that. I thought it said 50, but go ahead, Diane. You can go to the next one.
Does the 15% reduction stay permanent for fast food industry?
Not that I'm aware of.
Okay, if the staff has a degree that may not be related to their position plus additional training and certificate in the area of work, is that employee qualified under the professional exemption? For example, if they have a BA in early childhood education but an associate's for business management and they take on the role as an office manager, would that qualify as exempt?
Yeah, that would not qualify. It can't be that they have a degree. Generally, a BA is going to be insufficient for that exemption. Generally, they're looking for a BA plus something. And so, so you want to see a BA plus they went out to get something else. And if you're an office manager and your BA's let's say you have a master's in social work, that person wouldn't be qualified as professional because they're performing office work and they just simply happen to have a professional degree in another area. For example, if you hire an attorney as your administrative assistant or to work somewhere else in the department, unless, or organization, unless they're acting like an attorney, they're not exempt. They have to be covered. Back to your question, the salary threshold for certain exemptions, 2.51 states, except that the 2020 salary does not apply to the following two categories of employers to whom the below salary threshold only applies as of January 1, 2021, nonprofit employers with annual total gross revenue of under 50 million and for-profit employers with gross revenue of under 1 million. This is the last I printed off when it came out. I have not gone back to see if there's a change to that, but at least the one I printed out when it became final was 50.
Okay, this one might be tricky. If the coursework is required to obtain a training certificate required for work, does an employer need to pay for the time it takes the employee to complete the coursework?
Yeah. Anytime an employee is required to do something, they have to have a some type of like, for example, CLEs for attorneys. If you have, for example, a non-exempt attorney and you're paying them by the hour and you're not paying them, you're paying them overtime and those things, when they're at CLEs, they would have to be compensated. They don't have to be compensated at their regular rate, but they are doing something for the benefit of the organization because they still get to keep their job. There's an argument under federal law that if it's something general like CPR training and it's not required for the job, that you would have to. I don't see that exemption working as well under state law, but it certainly would be the argument.
In that particular case, could that be a requirement to apply, like that they must be CPR certified?
Sure. Yeah. If you say, well, or in the job description, you could say, look, we're not going to hire you until you're CPR certified because you have to come in the first day and have it. That would be an argument that they're not even an employee yet when they're doing that.
Okay, and last question here, and this gets back to the meals and rest periods. If employees continue not to take rest periods and when not monitored, and you've outlined so in the handbook and policies, can you discipline them for this?
I think that's a great, in the proposed order, I think that would have been a problem because it actually says does not have, as identified in there. In the new one, it states, it changes that to permitted and authorized. If you have an employee who is not taking those rest breaks, that would be something, or could be something that would be a disciplinary issue. I'd also, frankly, look to disciplining the supervisor, perhaps, because you want to make sure those supervisors are really stringent on the requirement to take rest breaks.
Yeah, that probably answers a lot of questions around meal periods and rest breaks in terms of people not taking their meal periods and rest breaks.
Yeah, that's a frequent question we get is, what do you do if, we just can't make the person and they want to work through? Well, there's an argument. The interesting question, one last point, Diana, which is the interesting question that I think will eventually get raised is that federal court case made it so that employees who don't take rest periods, even though they're compensated for that rest period, they're in essence working 20 more minutes, thereby you have to pay them 20 more minutes after they've left for the day. I wonder, will someone eventually file a lawsuit saying the employee who worked who worked their lunch periods, even though you paid that person, they're working an additional 30 minutes, so we need to add that to the end of the day. Will someone make that argument? I think someone certainly could. What will a court do? I don't know. I have to admit, I was really surprised at the rest period decision because in essence, my argument would be you're paying them for time after work, and you don't pay non-exempt employees when they're not working. So you don't have to under the law. So yeah, that will be the question. If they're not taking those rest breaks, you want to make sure if they're not taking it, that they understand that they're authorized and permitted to do so. And perhaps you have not only the handbook sign-off sheet, but every quarter you have or every year you have all employees sign that they understand that they are authorized and permitted. And what the reporting chain if they feel that they're not authorized and permitted, or if they feel they're being retaliated for taking their breaks. Document that authorized and permitted. I know I've talked over again. I'm sorry.
No problem
Lot to
at
go
all.
through in the new order.
We have one final question. Does the creative
Sure.
exemption still exist?
It does under federal law, but it's not referenced in state law. So the argument would be because it's been more beneficial to the employee to be a non-exempt employee, that perhaps that creative professional exemption is no longer the case under state law.
All right, we're going to go back to the breaks for a minute. Could you enter a collective bargaining agreement with non-exempt employees regarding rest breaks? Most of our people do not want to take lunch.
I like that idea. Hey, here's what we're going to enter into a collective bargaining agreement. I'd be careful jumping up and having your employees start unionizing. That has a lot of implications with it. So if you're not a collective bargaining employer, I wouldn't voluntarily do that simply so you can have the 5-minute rest periods or whatever it is instead of that. I could see that, but then you get into whole other issues where employees start coming to you and wanting to collectively bargain with respect to the vacation leave, for example, or other requirements, or grieve their performance improvement plans. It's once you open that door, you have a union. You don't need a technical union to have a union under the law. The National Labor Relations Act covers anytime employees work together to improve work conditions, not only when they have a union. So just entering into a collective bargaining agreement for the purpose of rest period, I would be a little nervous with.
Well,
and even
Michael,
then, even then, if you have that, it need not be 10 minutes every 4 hours, as we pointed out, but that the rest periods average 10 minutes every 4 hours and have at least 5 minutes of rest in every 4 hours work. So really all you're saving in that collective bargaining agreement is the difference between a 10-minute break and a 5-minute break. So I'm not really sure that that's worth it. Okay.
All right.
There we go.
With
Thanks
that, I
so
want to
much.
give a final plug to sign up for your employer advisory, because that's always full of really good information. And of course, that's here on the slide, so you've probably been looking at that anyway the last few minutes. So be sure to sign up for that. And on behalf of ASAP Accounting and Payroll, I want to thank you, Michael, for your time today, and thank all 205 participants for participating today. So thank you so much, everyone.
Thanks so much for the
Have a good
opportunity.
afternoon.
Thank you.